Employment law is an absolute minefield. And to be honest, it's not really my area of specialty. However, I have dealt with a number of clients over the years where you are the ambulance at the bottom of the cliff. Often it's quite nice to try and be the safety net at the top rather than the ambulance at the bottom. Generally speaking, you will have Section 2 of the Employment Relations Act, which is the good faith provision. Think of it like this: do unto others as you have them do unto you. The idea is, how would you like to be treated? Often that's the basis of where claims will come about from any employment dispute. The important thing to remember with the good faith provision is to be open and honest and communicate with your staff the issues you're having. Often the biggest issues happen when you start sending Facebook messages or an email or a text, some type of casual form of communication. You have to remember that while you feel you may have communicated with the staff, this is not a formal process. A staff member can easily say, I wasn't aware the seriousness of it because it was sent by Facebook or a Twitter. We all know what Mr. Trump can do with that. So the thing that it boils down to is, if you're starting to have issues with your staff, make sure that it's documented and you have those open and honest communications. Both agree that there's an outcome you want to achieve from it. Possibly even put a performance appraisal system in place to work out what's identified as a good outcome and what identifies shows that you're not meeting and achieving those needs. As an employer, it's also important to show that you've actually given opportunity to promote and to develop the staff member, and you've not left them to be ignored. A simple example could be an attitude that starts to develop within a staff member, and that attitude starts to undermine the harmony you've had within a good working staff environment. Rather than ignoring it until it gets to the point where it blows up like Mount Vesuvius, the idea is actually to bring that staff member to one side and say, hey, look, I've just noticed that there seems to be a sort of element of sarcasm or cynicism beginning to creep in and it's affecting the team. And you could have a casual conversation about it. If you then went to the second stage and said, look, we had that conversation, it's not really working, you have now lost your job. If you were an employee, you could feel blindsided by that. You weren't aware that there was such a seriousness about it, it was going to result in a job loss. But to move something to a formal communication, a formal letter, or a process where a friend's invited along as a support person, and you can actually have those conversations and try to show ways to change it. Now that's a subtle one that could be there. Some more obvious ones are turning up late. Often, you can imagine we deal a lot in the agricultural sector where an employee turns up 3 times late to the milking shed. The farmers, who are not known for their delicate manner in bringing their point across, might tell them to go and do nasty things to themselves and leave. That's not the right process to follow. As frustrating as it is, you can stand the employee down and you work through a process. If you find yourself getting frustrated in looking into employee performance and you really just want to get rid of them, it's best to engage professionals, because if corners are cut, it can result in some significant costs to you as an organisation. The process that works through is mediation. If 2 parties can't come up with an idea of what a settlement should look like, it would then go to mediation. The mediator will listen to both sides and work out what's fair in their view. Now, I've recently gone through one in a capacity I sit as a trustee, where we documented through HR support, came out the other side and still had to pay around $10,000 in wages, hurt, humiliation and legal costs. So even following the documentation to a mediation process doesn't say you're going to walk away without paying something. If mediation doesn't result in anything, you go to the Employment Relations Authority. Again, this is costly because that's the one where lawyers are involved. At the authority level, they will listen to the points of argument. Usually there'll be case law that's been involved, and they will make a judgment. If that judgment is disagreed with, it is appealed to the Employment Court, which is the highest authority in employment law. Now, by this time, what you'll be hearing is cost, 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 which is why a lot of it's dealt with at the mediation process. But it can also be dealt with even before you get to the mediation process by actually engaging in open and honest conversation with your employees about the performance, and you might get to a point where both parties actually agree it's best that they both part ways amicably. The key here is don't do it on your own unless you're an HR professional. Get help, get support, because it's so much easier to deal with it before you're the ambulance at the bottom of the hill.